This Mississippi case, as I understand it, I mean, it's not, I mean, you're also looking at Planned Parenthood versus Casey, and also could challenge Roe v. Wade here. Talk to me a little bit about this case and what makes this case, because I know that there were a number of challenges. What was it about this Mississippi case that this is the first one that's being considered, and what kind of impact is this going to essentially nullify? Like, I know the challenge with Texas's law and some of these others. Give us the legal insight on that.
Yes, this is the most significant opportunity that the Supreme Court has had in 2 generations to correct the gross overreach of Roe versus Wade, Planned Parenthood versus Casey, and all those terrible abortion decisions. So, you know, pro-life lawmakers across the states, Mississippi, Texas, and elsewhere, they've been passing pro-life laws at an exponential rate, especially the last 10 years. So much of these bans on abortion at 20 weeks, at 15 weeks, disability discrimination abortions, sex discrimination abortion bans, all of these are getting caught up in the legal system and going through litigation. The court can do whatever it wants. It decided to take up this case out of Mississippi and has said that the justices are going to answer specifically the question of, are any pre-viability bans on abortion ever constitutional? And so this 15 weeks, that's before what is considered viability, which has been a moving target. When Roe was decided, viability was considered 28 weeks. Now it's closer to 21, 22 weeks. So clearly, viability as a concept is arbitrary. And so what's so important about this case is that the Mississippi Attorney General, Lynn Fitch, she specifically asked the court to said, hey, to answer this question and uphold our 15-week abortion limit, which is very reasonable, very moderate, it doesn't comply with Roe versus Wade. So you have to overturn Roe and subsequent abortion decisions. So Mississippi's case is giving the court an opportunity to correct Roe versus Wade, to take the handcuffs off all the states so that they can pass laws that reflect the values of the people that live there. So yes, it's going to impact what's happening in Texas and really across all 50 states. It's a major, major opportunity for the court.
And even, Mallory, apart from the values of it, there's also the legal value. I was really, like, in the past couple of years, I have been reading a lot from, and I was actually surprised to read it from the source, you know, more progressive attorneys who have issues with the violations that they say Roe v. Wade established, because it actually completely exceeded the court's authority. Talk to us a little bit about this, because that aspect absolutely fascinated me, and it does make a lot of sense because it affects other things unrelated to abortion too.
Yeah, you're absolutely right. I mean, think about it this way. In 1973, 7 out of 9 unelected justices that were all men, we don't hold that against them, but it's just a fact, they undid in a single day every single state law that had been passed at that point limiting abortion. They legislated from the bench. They made policy. And for 50 years, nearly 50 states have been hemmed in by this Supreme Court decision and have been prevented from using the democratic process to debate and find consensus among the duly elected lawmakers who are elected by the people. And so it's a complete overreach. It's an abuse of the system that our government, that our founders gave us, that policymaking belongs to the legislative branch of government, and you know, the execution and the enactment of that policy belongs to the executive branch. So the justices just need to focus on the Constitution. And in 1973, they found a so-called right to abortion in the Constitution. It's online now. You can pull up a PDF, do a control find. There's no such thing as abortion in the Constitution. So this is the correction that the court could make is key. And we hope that they will correct themselves to get out of the policymaking business, retain what credibility that they have left, and allow lawmakers. In Mississippi, they want a 15-week abortion limit. In Texas, they want to protect babies when their heartbeats can be felt. All of these things speak to the humanity of the unborn child, which is evident from the moment of conception. But consensus, democratic consensus, is going to look different depending on where you live. But the court needs to take the handcuffs off the states so they can do their jobs.
Exactly. Yeah, you have to have the. I mean, you can't have the right of in pursuit of liberty without the right to life first, and then the pursuit of happiness and liberty. What gets me too about this is, from what I understand, and this, I'm not a lawyer. I play one on radio, but from what I understand over this was ultimately, structured as a privacy issue, but then it was such a reach to say that privacy, like protections and accommodations, exist to abortion on demand, which is a wild stretch to me. And apparently there were some Supreme Court justices that also disagreed with this. Of course, they never were all on the court at the same time, but that's remarkable.
Yes. Even the late Justice Ginsburg, said, I'm paraphrasing here, but that Roe was very poorly reasoned, and that the court essentially, for political reasons, they were trying to reach a certain conclusion, but there really wasn't any legal framework or framework in the Constitution to get there. Pro-abortion legal scholars have long derided the rationale used in Roe to give us abortion on demand up until the moment of birth. And they've created the status quo that we're in. The United States is one of 7 countries in the whole world, including China and North Korea, that allows abortion beyond 20 weeks, in fact, all the way up until the moment of birth, well past the point that the baby can feel pain. So who knows what those justices in 1973, what their intention was, but they created this unworkable. They thought they were settling the abortion question in the hearts and minds of the American people and in American law, and that simply hasn't been the case. This year alone, more than 500 pro-life bills have been introduced in state legislatures. 100 of those at this point have passed. And I think this just speaks to the desire of the American people to protect human life under the law, and this unrest that we have with the framework that Roe has given us, which is completely unworkable. But yeah, you're right that even pro-abortion scholars have long said, this wasn't well argued. And Justice Clarence Thomas, God bless him, he's the most outspoken pro-life justice on the court, who's specifically called for the overturning of Roe versus Wade. He said, once you get a decision you like, you keep crying stare decisis, going back to precedent. But that we have tons of precedents in the history of the court. Dred Scott, think of Dred Scott, that had to be overturned. They were clearly wrongly decided. That's the case here.
Schenck v. United States. Brandenburg decided that 60 years after.
Exactly.